Hello, friends. I'm Roger Royce. This is the 10,000 Startups podcast, where periodically I bring you original legal content of issues of interest to startup companies. I do emerging growth and venture capital in Palo Alto, California. And today's subject is when your contractors aren't. Lessons from the Google Maps driver's case. Now, this morning, on Saturday mornings, I like to get up and go find a new open. I live in the San Francisco Bay. I like to find a new beach to go swim because I like open water swimming. So today I decided to go to Clipper Cove up on Treasure Island. Got up early, drove 46 minutes, followed the Navi on my car, and it took me to a big dead end and a big sign that says road construction. And because this is California, there were 10 guys standing around talking to each other and one guy with a shovel. So I'll check back in 10 years or so when that road's fixed. But in the meantime, I was thinking, why did my Navi take me here? They ought to know better than that. So eventually I had to go, park in somebody's parking lot and hike in. And I did get my swim in, but that still bothered me. Well, if I had used Google Maps, I might not have had that problem because Google Maps hires companies to go out and make sure that their data is updated and that if the road is closed, your Google map won't take you there. And that is the company that is subject of our case today. So here's the issue that you should think about and why this is important to startups. And I'm going to dive into this deeply, but for now, just think about what you're doing in your practice. And I know you're all doing it. You've hired all these people and you don't want to bring them on as employees because that's a big hassle and it's expensive. And we don't have time to think about that anyway because we're in this explosive growth stage. So we'll clean it up later, right? So you have them sign a nice, big, beautiful independent contractor agreement. Maybe it's notarized. Maybe it's on legal size papers, so it's more legal. And then you could send them a 1099 at the end of the year, and you figure clean, simple, and cheap. And it is until somebody files a lawsuit that says, hey, these people aren't contractors, they're employees, and you owe them back wages. Well, that's what happened in this case. So let me give you a nice graphic so you can follow with how this worked. So there was a driver for a company that would drive around and gather data. So Google hires a company, a data company, say, drive around, take some pictures, get some data, update our maps so that I don't go looking for a swimming beach that I can't get to. So this company hired a staffing company, said, find me some drivers to drive around and collect data. Staffing company hires drivers. Well, one of those drivers, he happened to notice that he's getting a 1099 and he signed an independent contractor agreement, which he thought was a little weird because he was doing the exact same job before for another staffing company that treated him as a W-2 employee. Same job, but now he's a contractor. And he wasn't happy about it because he didn't think he was getting paid for all of his hours. Well, and what do I mean by that? Because he spent a little bit of time before each shift, like cleaning his cameras, setting up, that was off the clock. And he might have spent a little bit of time after each shift, taking the cameras off the car, whatever it is they do. So he brought a class action. Now, if you've listened to my podcast before, you know what a class action is. That's basically you have one plaintiff, one injured party that says, look, there's a whole bunch of people just exactly like me who suffered the same injury, and they're not likely to enforce their own rights because it's so small. So I'm going to sue on behalf of that entire class of people. And so even though his injury might have been too small for anybody to care, you get 1,000 or so people together, all of a sudden that small number becomes a big number. And in my career, I have seen successful, profitable companies completely brought down, completely bankrupted by class action lawsuits. It's a big deal. So we want to avoid that. You can't just say, well, it's a relatively small amount for each person, each potential aggrieved party, because it could be a large amount for all of them. So what did these drivers do that got everyone in so much trouble? They drove these routes They were assigned routes. They updated the maps, they mapped it, they verified the data. Okay, so far, so good. But here's the problem. They had to check in at the start and end of every shift. They had to be there by 9 a.m., and they were expected to put in at least 40 hours a week. Their routes were assigned to them. They couldn't turn one down, right? Their pay was a set salary. The company supplied the vehicle, the camera equipment, and the cell phone. And of course, my favorite detail, they all had to take a breathalyzer test 3 times a shift with the results reported back up the chain, which makes me wonder what the heck is going on in New Jersey. But aside from that, that sounds like an awful lot of employer control. And that's what the lawsuit said. It said, look, you employed when the driver showed up, how many hours they worked, what route they drove, what equipment they used, and even whether they've been drinking. That's not how you treat an independent business. That's how you treat an employee. And on top of that, there's this off the clock piece, and that's where that's where the damages piece comes in, because the drivers all say that they spent time, like I say, before and after the shift, just getting the car ready and then tearing it back down, cleaning the cameras, etc. So they were doing the boss a favor by not charging them for the time they did that. That turned out not to be much of a favor. Okay, so why does this matter? Because the label doesn't decide. And I've heard that so many times from people. Oh, don't worry, we're going to call them an independent contractor and then we're good. That's not how it works. You got to look past the paper to the reality of the relationship. Now, there's a couple different tests. Federally, there's this thing called the economic realities test. And the question is the worker running their own business or are they dependent on yours, right? Who controls the work? Who supplies the tools? Can the worker realize a profit or loss? How permanent is the relationship and how integral is the work to the employer's business? But some states, like New Jersey, where this case was filed, and unfortunately, for most of you listening, California, they follow a different test. It's called the ABC test. And under that ABC test, a worker is presumed to be an employee. And by the way, that presumed to be is a big deal because that means you, the employer, have to prove otherwise. They're presumed to be an employee unless you, the employer, can prove all three of these things. A, workers free from your control. Okay, so far, nothing earth shattering about that. B, the work is outside your usual business. And C, the worker is independently established in that trade or business. Now, it's the B prong of ABC that usually brings down some companies. That usually decides the issue. So look at this case as an example. Here we have a data company. They're in the business of driving around collecting data, and I hired people to drive around and collect data, right? Pretty hard to argue that that work was outside the business of the employer. So here in California, we call that AB5. And like I say, it just catches so many companies off guard. I've done many podcasts on AB5 here. Since California enacted AB5, it's been quite a bloodletting. And keep in mind that this is an extremely broad test. It has almost 100 exceptions. Coincidentally, about the same number of lobbyists in Sacramento, but put that aside. And you have to wonder about the wisdom of a law that requires 100 exceptions. But nevertheless, that is the law. And unless you're within one of those exceptions, you have to follow that rule. So, for example, if you're in a business that's not in one of those exceptions, say you're a wedding planner, you can be sitting in Incline Village, Nevada, and be an independent contractor, and the people that hire you are happy not to have to deal with the hassle of having an employee. And then you go across the line you cross that Cal Neva Casino and wind up in Kings Beach, California, and move there, and all of a sudden, poof, you're an employee. This is a state sensitive analysis. So for your startup, here are the lessons. This is why this case is so important. And the number one reason why is this really illustrates misclassification is not just an Uber problem. Okay, for many years, we thought about this as, oh, it's gig economy, it's rideshare, it's delivery. Well, here's a company that did pretty much straight ahead IT, right? Data collection, verification, mapping, operations. So if a startup has people out doing controlled operational work and you're calling them contractors to save on payroll taxes and benefits, boy, you're right in the crosshairs. Okay, this is the fastest growing category of employment lawsuits, and it's coming after industries that previously thought they were safe. Lesson number two, your contractor agreement will not save you. I don't care how pretty it is. And we all love a good template. And we all have that language. And in California, we even try to shoehorn into the exceptions through the language. But just keep in mind, the practice has to match the words on the piece of paper, right? So you could say, well, this is the business to business exception, which you'll find in my other podcast. Well, fine, but you have to match that business to business exception. And if it doesn't, the practice wins. Lesson number three, here's something interesting. These guys used a staffing agency. So they get sued. They're like, wait a minute, we didn't hire anybody. We had a staffing agency do that. Well, but they got sued, the data company, under a joint employer theory. And the idea is that if you exercise enough control over workers, you're on the hook as the employer, even if somebody else signs the check. So it's a co-employer type theory. So you cannot outsource this problem. So if you are using a staffing company, just make sure that somebody is taking ownership of this issue and that there's really good indemnification provisions in your contracts. Lesson number four, this is the other thing that people might not focus on. These little unpaid minutes are a huge liability. And I think any one of us who've been an employer, and I've been an employer, so I know how it is, you'll have somebody who wants to do you a favor by taking work home and then not charging you and doing this stuff off the clock. Well, they're not doing you a favor. They're creating a liability. And for a non-exempt employee, that time has to be paid. That's why it's a liability. And you multiply those small daily amounts across every worker, across, several years, poof, you got a class action with real damages. By the way, plus penalties and attorney's fees. So all time really needs to be tracked, including pre-shift, post-shift time. And the last lesson, number five, just make sure you know what your test is and what state you're in. Like I said, this is a state-specific test. If you're in California or in New Jersey, you've got an ABC test. And if you operate across state lines, you probably have to satisfy the stricter of the two, or the strictest of the tests. And a classification that's defensible in one state could be automatically wrong in another. Now, I am not weighing in on what the result should be in this case. I don't know nearly enough about it. I'm just telling you what I've what I've read online. And I do know that the case is out there, that it's being litigated, that it illustrates that there is some risk, because for me, I can tell you that I don't much care who wins or loses. Once you get sued, you've lost, right? Lawsuits are super expensive, and we want to avoid even being sued. So when I refer to this case, again, I'm not so much concerned with who wins or loses. I don't know who's going to win or lose. What I do know is you don't want to put yourself in a position where you do get sued. So what should you do, right? I know this sounds awful. It sounds terrible. And there are a few moves you can make. Now, as a startup founder, you've got a million things going on. You're growing quickly, and you're going to have these little fires that are going to pop up all over the place. You can't possibly put them all out. This is how Reid Hoffman describes it. You can't put them all out. You got to let the fires burn. Well, in my mind, when I look at this, yes, there's a lot of fires you let burn, but misclassification is not a fire you let burn. Misclassification is a Canadian wildfire. It's a fire that you absolutely have to drop everything and deal with and make sure you get it right, because it's not that expensive to fix in the front end, but it is extraordinarily expensive to fix after a class action gets filed. So here's what I would do. Here's the Monday morning checklist. Review all your contractor agreements. Make sure you could defend first of all, could you defend the agreement under the ABC test? And secondly, is your paperwork line up with the real world practice? And I would err on the side of employee if you have to err on anybody's side, even though it's a little more expensive, unless you're really willing to take that risk. That's it for this episode of the 10,000 Startups podcast. If this is useful, share it with a friend who's got contractors, Contractors. Remember, nothing here is legal advice for your specific situation. You change the facts, you change the result, talk to your own counsel before you make a call. I'm a lawyer. I'm not necessarily your lawyer, and this is not legal advice. It's only information. Thanks for listening, and we will see you next time.